there hadn't been deposition testimony or trial or anything. It was just, here's this waiver. It was signed. It was voluntary. So it really is a thorny question, and I think
that's why that very precise question that Ted just raised is what I'm talking about the process, what happens on the ground in the courtroom. What Ted said is what confronts people when they are subpoenaed in a grand jury context. Only the prosecutor knows the alleged crime that's been committed and the facts underlying the allegations to support that there's been a crime. You don't know. You have to fight with one hand tied behind your back. As my lawyer said in the Third Circuit, we're trying to hit a piñata without a bat. And the bottom line is that one of the things I proposed in my testimony is that Congress lay out not only the Justice Department guidelines, but a process in the grand jury context where the lawyer is representing someone who's being subpoenaed who has a key privilege, like a doctor or a lawyer or a journalist, must be told under a confidentiality agreement which they cannot share with their client, the nature of the offense and what is the theory behind it, so that they can argue appropriately, as we do generally in the adversary process, their argument on behalf of their client. This is something people don't understand. When you are subpoenaed in a federal grand jury and they are asking you to violate a privilege and testify, you are not entitled to know why. You are not entitled to know any of the facts. Now, sometimes you will know them because, say, for example, there's been a murder committed. You know what the crime is. In some cases, because of the vagueness and the vastness of federal criminal law, there is no way you can figure out what the prosecutor's theory is. Just going to give you an example. When I was subpoenaed, along with my partner, to testify against our client in Delaware in violation to violate the attorney-client privilege, we were not told what the crime was. We found out later that the crime was that we had wasn't really a crime, that we had hired Ken Starr's law firm to do First Amendment work for a county to contest the conduct of a local newspaper. That was the crime, that county money was spent to hire Ken Starr's law firm. Now, this is a rather elastic view of the criminal law, but nonetheless, given that it was in this Justice Department, we were not surprised by that. I'm a Republican, I'm allowed to say that. A disappointed Republican in many ways. So, the bottom line is, if you don't know that, you can't fashion legal arguments to defeat the prosecutor's purpose. Therefore, knowing what the facts were that came to the Justice Department from the CIA would be wonderful, because it wouldn't hurt the prosecution's case. The fact that somebody made a referral, for example, from the CIA that said this, 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 and this happened. Well, maybe this, and this didn't happen. In contesting a privilege so fundamental to the Constitution as a reporter's privilege or a lawyer-client privilege, it seems to me there ought to be some evidentiary leeway in the grand jury process, which is what we're talking about here, to allow for some real litigation about the question of an underlying crime. That didn't happen in this case because that's not the law. And it didn't happen even further because these waivers were signed by government employees. I mean, this case, the Valerie Plame case, this is a great case for people to study and understand how the law works and how it doesn't work and how it can be fixed. There are so many things in the process that this case shows need to be fixed. It is remarkable. And key among them is the question of the reporter's privilege and how it can be accommodated in a free society where we have obviously very important responsibilities to protect our covert officers and all that sort of stuff. But only if that's really what we're doing. Only if this person really is a covert officer. And only if there was real damage done, which of course apparently there wasn't.